Welcome to the CSLG seminar. This is the fourth edition of the seminar this monsoon semester. We're very glad to have with us Dr. Prabha Kotiswaran, and she'll be speaking on governance, feminism, and India's rape law reform of 2013. Dr. Kotiswaran is a reader in law and social justice at King's College London. She previously taught at SOAS London. She received her undergrad law degrees from NLS Bangalore and an LLM and SJD from Harvard Law School. Her main areas of research include criminal law, transnational criminal law, sociology of law, post-colonial theory, and feminist legal theory. Her 2011 book, Dangerous Sex, Invisible Labor, Sex Work and Law in India, has won the 2012 SLSA Hard Prize for early career academics. She's currently engaged in a collaborative project with Janet Halley, Rachel Riboucher, and Kila Shamir, which critically assesses feminist successes in several arenas of domestic and international law reform. Books resulting from this work include Governance, Feminism, An Introduction, and a co-edited volume, Governance, Feminism, a Handbook, that is forthcoming from the University of Minnesota Press. So this is the lecture would relate to the this very project that is currently in press. And I welcome you all, and Dr. you can give your remarks. We won't take in, for those of you who have not attended before, no questions in the middle of the lecture. We'll wait till the end and have around 40 minutes, then we'll have open to it.
Thank you. Thank you. This is such a pleasure. Thank you for coming today. And so I appreciate the context in which I'm presenting this paper following the trial court decision in the Feruki case. So today, obviously, I won't be talking about the case itself, but I'm more interested in the law out of which the case emerges. And I think there will be many more cases that get tested under the new law, and so I think it makes sense to have some historical perspective of the law and how feminists have related to it. And I also want to acknowledge that not actually living in India means that I'm very respectful of the fact that I may have gotten some of the political aspects of the lawmaking inaccurate. And what I'm hoping to do is to reflect with you on the criminal law amendment in the spirit of solidarity and the sort of reflexive vision of the Indian women's movement. And I hope it will be considered in that light. So as Nipun has already mentioned, this chapter actually is part of a co-authored book called Governance, Feminism, and Introduction. And the project really came about following on an article that we co-wrote in 2006 in the Harvard Journal of Law and Gender, which was on governance feminism. It was basically tracking the fact that feminists are not necessarily in a position of opposition to the state anymore, but that in fact, some of the time states actually listen to what feminists have to say, and that we have some influence. We weave in and out of influence. But we are not outsiders anymore to processes of reform. And that particular article dealt with, so we were 4 co-authors in that article, and we dealt mostly with international rape law. Janet Halley wrote about international rape law and the role of feminists in certain interpretations of rape in the context of the ICTY and ICTR tribunals. And myself and my other co-authors wrote on sex work and trafficking. So clearly, all 3 areas were areas of criminal law where we could very much see feminists seem to be influential. But what we realized over time was that after the article was published, that in fact there were stories of feminist success in other areas of law. And so we thought that this is not just a story about the criminal law and about violence against women, but in fact it's applicable more broadly. So the handbook that we are actually co-editing deals with a range of issues where feminism has become influential. So we deal, for instance, with transitional justice issues, we deal with law and development, we deal with whaling in France, for example. We have a chapter on that. We have a chapter on the representation of women on corporate boards, and we're also looking at cases like reproductive rights litigation. So in all of these cases, there seems to be some narrative of how feminists have become influential when it comes to the law. So what is governance feminism? At a very basic level, we think of governance feminism as every form in which feminists and feminist ideas exert a governing will in human affairs. So it's a very broad understanding of governance. And in the introduction in particular, we focus on how feminists have become incorporated into state-like and state-affiliated power. So the introduction itself is very focused on feminism in the context of state power. And in saying this, we don't need to essentialize governance feminism. It's not like it's a school of feminism and that you can belong to it and you're always part of that school. And it's not as though a particular person is a governance feminist all the time. So there's no identity associated with governance feminism. And there's no normative judgment either. So it's not a question of there are pure kinds of feminism and then there's governance feminism. There's no good, bad, pure, impure, inside, outside, authentic, inauthentic. There are none of those judgments that are being made. I think my own project has been to map out in a descriptive way what has happened with the 2013 Act, and then to assess it from an analytical point of view as a lawyer. So actually, my own chapter on I teach criminal law and I teach rape law in the UK. But my interest in the amendment came about because as a feminist criminal lawyer, I began to get more and more uncomfortable with some of the state documents that were coming out on this issue and some of the statements that feminists were also making. And I also want to say that apart from working on rape law, I'm also involved very much in the areas of trafficking and sex work. That's where all my earlier work was. So it's also having dealt very much with the social movement of sex workers. A lot of my work is ethnographic, or used at least an ethnographic method. So it was very much engaging with communities of sex workers and how they viewed the law and the state. So my understanding of rape law really comes also from that location in the past. So in my paper, which I'm very happy to share with you, it's available on SSRN and I'm happy to share it with you for mailing list as well. What I do is try to look at the 2013 reforms and ask 4 questions. And only 2 of those questions I'll deal with today. But I'll just allude to the other 2 in some brevity. So the first question I deal with is, can we discern the emergence of Indian governance feminism? And I'll just say GF instead of governance feminism from now on. So I argue yes, that you can actually find the emergence of Indian GF, and I track this through 3 parameters. One is a growing reliance of feminists on criminal law. Second, a deep commitment to a highly gendered reading of sexual violence. And third, a diluted oppositional stance towards state power. Those are the 3 parameters that I track. So that's the first question that I look at. Now, the second question which I look at is, what are the implications of GF for transnational feminism? That's not really something that I need to deal with it simply because of my own location. But I just want to clarify that often my co-authors that I'm writing with think about my chapter on Indian GF as simply, reflecting or being influenced by Western carceral feminism. So they just say, Indian governance feminists are in this transnational zone where they're negotiating treaties and filing shadow reports and so on. So there's a way in which radical feminism from the US is trickling down somehow to Indian feminists. And as you can imagine, I have a reaction, a bad reaction to that. And I generally think that feminist movements around the world are gaining influence. And if that's in fact the case, the nature of these movements is changing, then we can actually discern varieties of GF. There are different kinds of GF which have their own normative, theoretical, and activist histories and profiles. And I suggest that Indian GF differs from Anglo-American GF in at least 2 respects. One is that in the past decade, US radical feminism in particular has been very comfortable with carceral projects. Now, Indian GF, even while relying on the criminal law, is also quite skeptical of it. It's certainly more skeptical than US radical feminism. Simply given the violence and corruption of the Indian state. and also given its own intellectual roots in materialist thinking, which views the state as an instrument of class domination. Another significant difference I think that Indian GF has from Anglo-American GF is the fact that we have a strong political left in India, and therefore a fairly vocal materialist and even Marxist feminism, which calls into question radical feminist tendencies within Indian GF. So there are points of convergence and divergence between radical feminism and materialist feminism, and these have political effects. And I see them most in the context of sex work, and I'll mention them briefly in just a minute. The other difference, I think, in the Indian context and the American context is the presence of state feminism in India. And so state feminism was a term which was coined by Scandinavian feminists for their own version of democracy. And many of you may be aware that democracy was a term that Australian feminists came up with to describe feminists who were in a political movement who then assumed positions of power in government. Right? So I just want to say that both democracy and this idea of state feminism are precursors of governance feminism, though my co-authors may not agree, but I put it that way. So I argue that Indian GF has been facilitated by this atmosphere of state feminism through institutional sites such as the Ministry for Women and Child Development, which was a department for a long time, and of course the NCW. And then there are more ad hoc venues of state feminism, including the Law Commission of India and the Burma Committee. Now, related to these two questions is my third question, which is if feminism is actually Indian feminism is finding a foothold within Indian state power, then how does it relate to other forms of governmental power, where state power extends beyond the juridical into the discursive or governmental realm? And here I think it's actually interesting. I won't talk about it in any detail today, but I'm writing a companion chapter for the handbook that I mentioned earlier, where I'm looking at the Criminal Law Amendment Act of 2013, but from the perspective of sex workers groups. And what we can see is that this act brought together both rape and trafficking as two substantive issues for law reform, and they both have distinct mobilizational profiles, both in temporal and substantive terms. And struggles over rape law reform are core to the Indian women's movement, whereas trafficking has far less domestic resonance. And its historical association with sex work has meant that the ambivalence that Indian feminism has always experienced in relation to sex work means that Indian feminists have generally ignored it. I'm not saying they're indifferent, but ignore I mean in the sense of not actively lobbying for or against the recognition of sex work. Because they have this ambivalent and quite complicated stance vis-a-vis sex work, they have not kept trafficking on their radar screen to the extent that maybe they should have. And what the 2013 process did was bring them both in the feminists and the sex workers group in conversation with each other, as both these areas of law were getting reformed. And here I just want to suggest that Indian GF formed an interesting alliance with the sex workers groups. Simply referred to their reading of the traffic provision in the Act, because the Justice Burma Committee had, as you know, had conflated sex worker trafficking, and sex workers groups had picked up on that quite early on, and I think feminists supported them in then trying to get the Burma Committee to actually change its position on it. So that's the third question. Now the fourth question is the so what question. So what if Indian feminism has assumed this governance mode? There's nothing wrong with it. Obviously we are trying to seek influence, and there's actually that's not necessarily problematic. So I think, and I think that's quite right. And what I want to do instead is to simply put on the table the fact that we can think about Indian GF, and that we shouldn't feel uncomfortable about having this influence. Instead, we might just want to assess, and I think which we already do anyway, the distributive effects of this rape law, with a view to further reflexivity. And for this, and this is a portion where I may not be able to get into it today for lack of time, but in the paper itself I perform what is called a legal realist analysis, which is influenced by American legal realism, to think about who are very much came from a Marxist train of thought, and have a certain understanding of how we should analyze legal rules. So what I try to do there is to perform an analysis of the amendment for different categories of defendants and victims under the rape. So if I have a chance to get into that, otherwise I'll just map for now the emergence of Indian GF. So again, I won't elaborate on this, but in trying to assess Indian GF, there are three categories or three concepts that I was thinking about, and I want to thank Professor Bakshi for this. He talks about regulatory reform, which is changes to the black letter law, and then social reform, which is literally changing the hearts and minds of people, and then governance reform. Governance reform often bridging the gap between regulatory reform and social reform. And governance reform in the Indian context is quite complicated because of the high levels of informality in law enforcement, a weak state, corruption, and sticky social norms. And these sticky social norms are something you see across the world when it comes to the question of rape. And I think also, it's also complicated because of the perversity of the Indian legal system. And I think Pratiksha has written very beautifully about how the Indian legal system actually generates these perverse outcomes. So, in my talk today, I just want to discuss regulatory law, and that is substantive criminal law rather than procedural and evidentiary laws. So again, this may all be quite familiar to you, so I won't go into much detail here, except to say that since the Indian Penal Code was introduced in 1862, the rape provisions have been substantially amended only twice, once in 1983, and then in 2013. There were obviously changes in the evidentiary laws in between. And so, do you want me to go into what the 83 Amendment did, or should I just assume you? A little bit? A little bit, okay. Okay, so obviously in 83, post-Mathura, the Parliament amended the rape law and it incorporated several recommendations of the Law Commission of India. And the amendment essentially expanded the grounds for finding lack of consent to include survivors who are of unsound mind, intoxicated, or who were drugged. Now, this amendment did not define consent. And although the Law Commission recommended inserting a rebuttable presumption of lack of consent in all instances where the woman claimed, the 83 Amendment only allowed the presumption for custodial rape and rape of a pregnant woman and gang rape. Now, under the newly introduced Section 114A of the Indian Evidence Act, one section interposed by a man in a position of authority was proved, and the rape survivor said that she did not consent. A lack of consent was presumed. And then you had minimum punishments of between 7 years and life were introduced, along with increased penalties between 10 years and life for custodial rape, gang rape, and rape of a pregnant woman, and rape of a child below the age of 12. And then, of course, you also know that in 83, as part of the amendment, courts could impose lesser penalties if they do special separately under a separation decree or customarily. There was no immunity for the husband, but the punishment was lower than for stranger rape. Similarly, marital rape of a wife between the ages of 12 and 16 attracted only a 2-year prison term. And you also have a legally paternalist move, even consensual sexual intercourse between men in positions of authority and women in their custody was criminalized. And then there were provisions relating to rape shield laws where you produce evidence as to the character of the survivor. Those provisions were not amended in 1983. And so after this, these amendments in 1983, there were many, many points of suggested reform, but actually reform to the law did not happen until 2013 in the form of the CLA. So the CLA is a culmination of 35 years almost of feminist efforts to force the state to reform rape law. And I want to argue that between 1979 and 2013, the relationship between Indian feminist groups and the state and criminal law reform underwent a substantial transformation. Not only were feminists slowly but surely clarifying their own legal understanding of rape, their ideas were also beginning to have influence within the state, both to the NCW and the Law Commission. And post-Nirvaya, I think the Burma Committee was the most open point of reception for feminists. And although feminists ultimately lost out on very crucial issues, including marital rape by the armed forces and age of consent, I want to argue that their successes were not insubstantial. And you could trace it back to a very powerful theory that they proposed of sexual violence. So I want to now address 3 specific dimensions of Indian GF, and 2 of them are quite closely interrelated. So you'll see me go back and forth between them. That's the increased reliance on criminal law and the gender understanding of rape. And then, of course, there's a third aspect, which is access to the state. And I think that's been very well documented, so I won't go into it much detail. So the first parameter for assessing Indian GF is feminist increased reliance on criminal law. So I think compared to feminist movements elsewhere, a crucial point of departure for Indian anti-rape struggles is the high levels of sexual violence inflicted by the state itself, right? And the Mathura case itself is an example of that. So if you look at the arc of Indian feminist advocacy against rape, it extends from its opposition to custodial sexual violence inflicted by the police in the 70s and 80s to today contesting sexual violence perpetrated by the armed forces in conflict-ridden parts of the country. So resorting to the state for criminal law reform has always been a fraught affair for feminists for fear of its misuse. And the Indian women's movement has also been acutely aware of the symbolic promises of law reform, given its chronic under-enforcement by a weak post-colonial state. However, as I will show, the zone of opposition to the criminal law has reduced over a period of time. So today, what we see, at the end of these 35 years, you find that feminist opposition to the death penalty for rape is a far cry from their deep suspicion of all aspects of criminal law post-Mathura. Right? So, due to constraints of time, I'll offer you only a couple of snippets of how this shift has occurred, and you can read my paper for the rest of the arguments. So, feminists inserted themselves in the law reform process post-Mathura pretty early on. So, in 1980, the Law Commission of India, for instance, met with 8 women's groups. And it's really interesting to look at the ambitious reforms that they suggested to the commission. So they had elaborate changes for gender matching. By gender matching, I mean, you have women in several institutions because they are assumed to understand women's problems better, so they'll be more sympathetic to relate with them. They called for gender matching, they called for female social workers' involvement in rape investigations alongside the police, as well as in the trial itself. Now, the Law Commission rejected all these demands, citing that this is impracticable and that in fact they were afraid of a trial by the public. And they thought the trial would be used to wage caste and class warfare. And Geeta Mukherjee, member of Parliament, in fact tabled an amendment to presume consent in all cases of power rape. But of course this was also the post-emergency years, and again you'll be quite familiar with this. There was no surprise that feminists were actually deeply suspicious of state power. So Ratna Sarkar, who, as you know, famously penned the open letter to the Supreme Court, was once asked why they had not demanded a blanket presumption of lack of consent in all instances of rape, rather than only in custodial situations. And she responded by asking if we wanted to hand over all power to the government just after they'd come out of the emergency. So she says, I quote, "Don't you realize that such power could be used to stifle all political dissent?" And then, of course, human rights groups also reminded feminists that a blanket presumption of lack of consent could be used by managements against trade union militants, by rural vested interests against revolutionary activists, by caste Hindu chauvinists against rebels. Now, in 1981, feminists' intense suspicion of state power meant that they were even opposed to suggestions like in-camera rape trial, which today it's just feminist common sense, who could possibly argue against that. But back then they actually passed a resolution stating that they thought these trials were an attempt to impose press censorship. And even after the 1983 amendments, feminists vowed to take great care with future demands lest it be used to curb civil liberties. And they looked at their apparent successes and noted in 1994 that actually conviction figures for rape post-83 were lower than pre-1983. And therefore it wasn't clear to them that criminalizing custodial rape had actually been effective. So the suspicion of criminal law lasts through much of the 1990s. But what happens is that I think Indian feminists increased reliance on the criminal law between 1983 and 2013 also then becomes related to their reconceptualization of rape during this period. And here I think, I'll just say very briefly that one can think of 3 major feminist approaches today. One is rape as violence, the Canadian model. The second approach would be rape, where we think of as uniquely gendered violence, and this has been thought to be the Indian feminist approach. And the third position, rape as violence, where violence precisely is the sex, so the radical feminist model. And we can see that Indian feminists have always privileged the second idea that there's something special, sexual, and gendered about rape. And so what I want to propose is that although the second and third approaches appear distinct on paper, actually they are ideologically highly compatible. And there's always possibilities for slippage between the two of them. So for example, consider the third approach. The third approach is where radical feminists understand all heterosexual sex as coercive because it is only force or defined to include inequalities of power, meaning social hierarchies, and consider replaced with a welcomeness standard that the law of rape would begin to approximate the reality of forced and unwanted sex. So that would be the radical feminist understanding of, basically being very skeptical that consent would have any value where there's endemic coercion around us due to patriarchy. And then there are other, and it's interesting actually, there are other philosophers of criminal law who also agree with this position. So for example, Jonathan Herring, who is a criminal law lawyer at Oxford, and Michelle Dempsey, another radical feminist, they argue that any penetrative sex by a man with a woman would prima facie be a moral wrong, right? Where it was unjustified, even if it was consented to. So to be justified, such sex must confer value, respect and dignity and humanity on the woman, right? And a major reason for this position is the uniquely gendered nature of rape and its violence. In effect, the second approach, right? And conversely, if you look at feminists who have a second approach, like many Indian government feminists, they attribute sexual violence to pervasive gender hierarchies, and so this appreciation for social coercion led them to name all rape as acts of power. And as I've already said early on, this idea of power rape was presented to Parliament, and the Law Commission of India also recommended it. So,
are you able to hear at the back? Sorry.
That's fine. So what I want to say is that the idea of power rape was already articulated in 1983, but you find an extraordinary expansion of it in 2013, where the presumption of lack of consent is extended well beyond custodial situations to everyday situations of dominance. Okay? So there's a way in which Indian feminist demands comes close to what the radical feminists proposed. And so in fact, over the past 3 decades, I find that there's a switch back and forth between the second and third positions, and that comes with a price. And we know that this was constantly negotiated when it was contested. This position of Indian feminists was contested by LGBT advocates, children's rights advocates, and 2013 Marxist feminists. So if you look at the chronology of rape law reform, again, I won't go into too much detail, but in 1993, you have an understanding of rape in terms of sexual assault. Okay? So I'll just say, so there's a terminology when you think of it in terms of sexual assault. There are two kinds of sexual assault. One is penetrative, penile and non-penile, and one is non-consensual touching, gesturing, and exhibiting any part of the body for a sexual purpose. So that's 1993. Now in 1999, as you know, again, Sakshi, a feminist legal advocacy NGO, filed a petition in the Indian Supreme Court relating to child sexual abuse, and then of course they requested the Law Commission of India to then submit the 172nd report on rape law reform. And they, of course, the Law Commission recommended replacing rape with sexual assault, but sexual assault that was gender neutral both as to the defendant and the survivor. Okay? So penetration was expanded into non-penile penetration, and the Commission failed to define consent or delete the marital rape immunity, and it pegged the age of consent at 16 and retained judicial discretion on minimum sentences. And then, of course, they proposed some offences of aggravated sexual assault and had suggestions on Section 377. I won't go into it. So, although this was a paradigm shift for many feminists from the 84th Law Commission in 1983, feminists fiercely opposed the gender-neutral offence of sexual assault out of fear of its misuse. Right? And at this point, I think there was also, even LGBT groups had the sense that this didn't, they were also against the gender-neutral formulation because, in fact, Section 377 was still on the books and they had absolutely no rights. So feminists, in trying to negotiate this difficult challenge to their own position, called for a gender-neutral offence to deal with child sexual abuse. And they said, in fact, if you have a separate law, that's even better. So, of course, despite all these efforts for reform in the 1990s, there was limited momentum for legal change. And it's in 2010 that you find, when the government proposes fast-track courts for rape, that several women's organizations write an open letter to the law ministry. So again, I won't go into it because they wrote a letter, then the Home Ministry proposed a criminal law amendment bill of 2013, which they, of course, decried as a greatly diluted version of the Law Commission's proposals. But what is interesting here is that feminists said, well, if the government can't get this right, let's do it ourselves, right? So what I find fascinating, and I analyze this more in the paper, is that they draft their own criminal law amendment law, and I call it just because it has this theory of sexual violence. I call it the sexual violence bill. And in many ways, it's an aspirational statement of the Indian women's movement on sexual violence. Now to a criminal lawyer, and I think there are some of you in the room, it's broad formulation of offences which simply jump at you, right? Because it falls short of many civil liberties principles that limit criminalization. I mean, this is routine first year criminal law, literature that students, might be exposed to here. Certainly in the UK, it's a very, we understand criminal law only through the lens of the harm principle. And there were principles like precision, clarity, fair labeling. All of that seemed to be compromised in the 2010 bill. And I would actually say some of the bills were some of the offences were broad enough to be constitutionally suspect. So anyway, so that is one aspect of the bill. The bill, in fact, then proposed a new IPC chapter entirely on sexual violence. So offences against the body is not enough. We want a separate chapter in it. And there was a sense of sexual crimes, and this is from the statement of objects and reasons, which says sexual crimes form a continuum. It includes a whole range of acts, and you have to think of it in terms of harm, injury, humiliation, degradation, and so on. Okay? And you find, again, a whole list of offences that we eventually see in 2013 around stripping, disrobing, parading someone naked, sexually humiliating words, and so on. So what is interesting in that particular bill is that feminists segregated these sex-based crimes as special, different, and potentially more harmful than other bodily offences. That was one. The second was that they boldly reconceptualized consent as the woman's unequivocal voluntary agreement, including numerous situations where lack of consent was presumed. So this is where we begin to see that where lack of consent was to be presumed, according to them, was not just the custodial situations involving the police, but also situations of collective violence, intimate violence, and where the perpetrator was in a position of social, political, and economic dominance. Okay? And economic and social dominance in that bill was defined as situations of religious, ethnic, linguistic, caste, and class dominance, including but not limited to both formal and informal employment situations. And so you find that there is a broad construction of coercion which risks recasting even consensual sexual contact between a man and a woman from different backgrounds as sexual violence. So there's already a red flag for women's sexual agency. Okay? And apart from that, there's also some aspects of international criminal law that they bring into the bill. But what is interesting is that they also oppose gender neutrality, and they articulate it in very interesting ways, right? So by then, I think it's pretty clear in this bill that the Indian women's movement was basically a women's movement, and that opposition to gender neutrality was in fact integral to its core identity. So they basically, feminists thought that given the rape culture in India, we can't afford to have gender neutrality. It's a luxury, and maybe in the West it's okay, but not so much in India. But this pragmatic argument that this provision might be used to file false complaints against women, it's a pragmatic argument, very soon morphed into a normative argument to say women never rape. Okay? And I think also what's interesting is because by now there were also challenges from the LGBT community and children's rights advocates on the issue of gender neutrality, and the way feminists negotiate this is as follows. So feminists could have had three options at this juncture. The first one is to simply make it gender neutral, rape gender neutral, as to the survivor, but not as to the defendant, right? The second option is to create separate offences within the same statute against the rape of women, children, and LGBT persons. And the third would be to have a separate legislation altogether for these constituencies. Now, what does the Sexual Violence Bill do? The Sexual Violence Bill adopts the second strategy, and they propose three distinct offences. So you have an offence of sexual violence by a man on a woman, you have sexual assault by a man on a person other than a woman, and you have sexual assault by a person on a child. So what you see here is a very deeply gendered, radical feminist view of violence against women. So in their sense, only biological men could commit sexual violence against adults, and biological females could not, right? And so there's an inability to imagine that women could be sexually aggressive in situations of communal violence or other kinds of violence. And they also thought, if you look at the terminology, it's also quite clear that when violence is suffered by females, it's considered to be graver than non-females. So sexual harm against women is sexual violence, whereas against men and transgender persons and children, it's merely sexual assault. Right? So you find a hierarchy, which is why you have a separate offense of sexual assault of transgendered persons. So anyway, so that's a glimpse into where feminist thinking was in 2010. And then subsequently, of course, you have a special law on sexual violence against children, but the challenge that was posed to the gender neutrality question by LGBT groups never really went away. And then, of course, it comes back to haunt in 2013. So, and here's what I want to say, that, so this is 2010, and you might argue this was just a proposal, what happened next? What happens next is the Criminal Amendment Bill of 2012 is proposed by the government, it's tabled by the government on December 4th, 2012. This is literally a few weeks before the Mumbai incident. And my own sense is that if you want to appreciate the difference that feminists made to the rape law, you have to look at the difference between the 2012 bill and the 2013 Act. I think it's the difference between the two laws that captures a lot of this feminist theory of sexual violence that makes it into the law eventually. So again, I'm not sure I'm doing so well on time, so I'm going to move along. And again, I won't go into the ordinance. I'll just talk about the Act. And as you know, the Verma Committee report, again, it's a fascinating report, and I have a pretty long critique of many aspects of it. So what I'll just simply highlight, I'll simply say that I think I think Indian feminists not only wrote into the committee but actually met with the committee. So I think 92 feminists and 80% individuals actually sought audience with the committee. And even took credit for dissuading the committee from suggesting the death penalty. So it's clear that they had some influence at some level with this state body. But what I want to point out, and this is quite crucial I think, is that Indian feminists were not alone in influencing the Burma committee. So if you look at the acknowledgements, the committee thanked at least one American radical feminist, Diane Roosevelt, from Harvard Law School. And what is important also is that there are some relatively new single-issue NGOs like Bachpan Bachao Andolan or BPA who are extremely influential in relation with the Burma committee. And the committee members, of course, were also acquainted with many feminist lawyers, which, as you know, Justice Verma wrote the Vishnaka judgment, and Justice Leela said was part of the Law Commission of India as well. But what is interesting is that the third committee member, Gopal Subramanian, in his position as Solicitor General, had represented the government of India in the bar dancing case. And I only mention it because I read in that decision, actually, he quotes Hartsville McKinnon, which I thought was just interesting. And he's obviously on the committee, and then he was also on the public interest litigation brought by BPA on child trafficking in circuses. So there's a very interesting way in which actually there are many constituencies that are speaking feminist talk, gender speak, literally. And so therefore the second longest chapter in the Burma Committee report after rape was on trafficking, right? And these are all abolitionist groups which are against sex work that actually had, I think, brought trafficking into the Burma Committee report. So there are lots of arguments in the Burma Committee that mimic a radical feminist idea, of how if you start with any kind of sexual activity, it's a slippery slope, and if you don't control it, it'll actually end up with aggravated sexual assault. So here it is, a quote: aggravated sexual assault must include all stages of affront to human dignity, which is a quintessence of human rights, beginning with any act with a sexual overtone. So there are many such nuggets in the Burma Committee report. So there's a suggestion here that maybe to eliminate sexual subordination, you might just do away with sexual activity altogether. So then you have the Criminal Law Amendment Act. Again, I won't go into too much detail except to pinpoint the places where you can see quite directly how it because there's always a there's an argument that Indian feminists make, which is that, the Verma committee said something and something else came out at the other end. It's an input-output problem, and actually we would distance ourselves with what happened. I think that's true to a certain extent, but I think there are core aspects of the new law that actually were borrowed from some of these feminist texts, and if not from the feminist texts, certainly from their, ongoing discussions with the government. Right? So, for example, the CLA's definition of consent. Right? A substantial portion of this definition appears in the 2010 Sexual Violence Bill and the Verma Committee report before being modified for the CLA. Similarly, I think if you look at explanation 2 to section 375, which clarifies that the lack of physical resistance shall not be considered as consent, again formulated in the Sexual Violence Bill. And then if you look at the grounds for aggravated rape under section 376(2), they've been doubled. We go from 7 to 14 grounds, and many of these additional grounds were actually proposed as far back as in 1993, and they're listed in the Sexual Violence Bill. Okay, and they deal with the status of the defendant, the status of the survivor, the harm that was caused in the context of the rape, and so on. Again, I'm not able to go into a lot of the provisions of the CLA, except to say that there's a dramatic number of crimes, very high penalties, many reversals of burdens of proof, non-bailable offences, and so on. You are already familiar with this, I suspect. So a lot of these offences which made it in 2013 were not there in 2012. In 2012, I think the only one that wasn't there was acid attacks, but by 2013 you have voyeurism, disturbing, trafficking, sexual harassment, and so on. So I think all of this suggests that feminist influence, there was feminist influence on the Indian rape law. And I think generally the universe of criminal law actually expands, right? So you can see that with the expansion of the idea of rape from rape to sexual assault to sexual violence, you're actually expanding the scope of the criminal law. And in fact, the feminist main criticism of the CLA right after it was passed was its under-criminalization, that it didn't talk about marital rape. Now, obviously I don't think the immunity should be there, so don't get me wrong, but I'm just saying that at that particular point, and now of course there's been more critique afterwards, but at that particular point, in fact, the main criticism was its under-criminalization. And then of course we know what happened with the LGBT community, which is very betrayed, I think, by feminist insistence on gender neutrality. And I think the other critique that has come in, which I want to take quite seriously, is that of the Marxist feminists. You have Nandita Aksar, you have a socialist theory of rape, in the 80s, and all of that just disappears somewhere in between. And then you find this suddenly post-Nirbhaya, through Maya John's arguments, some of which are very problematic. But the one thing that I am persuaded in her theory is the idea that women and men in varied class positions can actually develop very different states, and in fact contrasting states in the same criminal law. So you can take the same rule of criminal law and it can have very disparate effects on different categories of men and women, and I think that's a refreshing argument. Now all the other arguments around male sexuality being hydraulic and so on, I think are interesting, but it's a very old tradition of materialist feminist thinking on sex, and also it's also somewhat naive to think once there's redistribution, we'll have consensual, happy sex, and we should aim towards that in the future. So I think I've tried to elaborate on the first two dimensions of GF, and the third dimension I won't go into. I'll mention very, very briefly. What I think is striking is both the emergence and consolidation of state feminism. So we don't have to do public interest litigation anymore. We are right there drafting the laws. There's a shift. And I think it's something other feminists could map in a more concrete and rigorous way. This is just my impression. The other aspect is that the increasing role that lawyers have played at the forefront of feminist struggle. And this is one of those conundrums within the Indian feminist movement. We are always saying how we're torn. We actually hate the significance of the law, yet it seems to be the most productive site for feminist engagement in relation to the state. So the law space is quite paradoxical, I think, within the women's movement. But what I do think has happened is that moderate equation, here again, it's Upen Bakshi's, he has a typology of how different constituencies deal with the law. And in his typology, feminists might have been moderate in relation to the law. but I think we've become evangelical now. And it's across a whole range of areas. It's rape, it's sexual harassment, it's domestic violence, it's child sexual exploitation, it's trafficking. So the other work that I do is on the trafficking bill, which has reached its 9th draft with the Ministry of Women and Child Development. And it's horrific looking at the trafficking bill. It's pouring laws, right? And I think what is interesting is that feminist lawyers have come up with very, clearly some very nuanced law reform proposals, but also they certainly played an important role in passing and pushing for these laws. And what is problematic, however, is the fact that any critique of the 2013 law, including in the Faruqi, post-Faruqi, is a way of throwing lawyers at the feminist masses and saying, look at our feminist lawyers, they have told us that there's nothing wrong with the law. We knew all this all along, that you could, the testimony of the victim, if it's credible that you accept it. Nothing has changed with the 2013 law. Or that the reversals of the burden of proof, oh, we knew about that. It's not, it is still a rebuttable presumption. It's not that the defendant has no right to defend stuff. That I find really quite problematic, to throw feminist lawyers at the feminist masses. So I think I'll just stop there. Because my host is quite patient. Do I have 2 minutes?
Yeah.
Okay. So I just want to say something very quickly about so what, right? Now I want to come to the so what question. So we had some victories, and maybe we haven't done so well on other aspects of the law. And as the test cases emerges, we can count up, who's getting hurt. So how do we do that, right? So for this, I use a legal realist analysis, and there are 2 assumptions that a legal realist analysis makes. One is very intuitive to us leftists, which is to say, every time you deal with a particular area of law, actually there are many other legal rules in the background. So if you're actually dealing with criminal law, the action is also in family law, it's also in property law. They are all in the room, right? So you just don't obsess with criminal law. You also look at the other background legal rules that are affecting that particular situation, right? So a simple example is labor law, right? Labor law is not just you have to deal with the provisions in the labor statute, but actually it's closely related to how we have set up property law. So that's one assumption. The second assumption is that a legal system does not deliberately decree one thing or the other. So for feminists, it would mean that you don't simply attribute miscarriages of justice in our context to the fact that the legal system is thoroughly patriarchal or capitalist or reflects capitalist patriarchal interests. So it's not this overwhelming sense that the legal system preordains a particular outcome. Instead, the idea is to think of men and women both as having a certain bundle of legal rights and obligations, and they have different levels of bargaining power vis-a-vis each other, depending on where they are placed in society. And they negotiate with each other. At a particular instance, it's likely that in more cases than not, women lose out. Right? As a good feminist, that's what I would also argue. But I think it's also more fluid than that. And so my legal realist analysis is not post-feminist. All it says is, the CLA, you can have a fluid understanding of how it's rearranging power. And so in the paper, I think about rape relationally. So I look at different categories of non-consensual sex. For example, there are non-consensual sex between strangers or between parties who are known to each other. A lot of our rape cases involve that. Or you might have non-consensual sex between parties who are already in a pre-existing legal relationship. So they are either married or they are in an employment relation. So it's not enough, I think, to talk about rape in these generic terms, but that you might want to think about it relationally. And there would be another category of legal subjects who are affected by this law. And those are people who engage in consensual sex. Where they engage in consensual sex, where third parties object to the consensual sex, again, this is very well documented. Families who don't want their sons and daughters to engage in certain kinds of sex. And third, where consent is contingent by one party, is contingent on the satisfaction of a certain condition. Right? So again, I don't have the time to go into it all, but I just want to suggest that if you look at rape relationally and then assess the different rules of the new law in terms of how it plays out for these different constituencies, it's not so clear that this is a feminist victory. And it seems like different constituencies might either lose. I think there are some men who will definitely lose, and there are some women who will definitely win, because one could argue that, you know, there are, the Act has certain, you know, reorients governance in some fundamental ways in terms of, you know, recording the FIR, in terms of the free hospital treatment, all of that. So some women will benefit, and some would actually be indifferent to it, and some would derive some symbolic, you know, strength from the law. So I think it's very disparate what the effects of this law might be. So it's very hard to say upfront what the effects of the amendment would be. But I think going forward, what I would actually suggest is that we might want to acknowledge, bringing it all back to governance feminism, I think we might want to acknowledge that feminists have been influential in this round of rape law reform. You know, many words that we carefully crafted have made it into the law. And that, in fact, if we have had that some influence, we may not always win, but if we have some influence, then maybe we should also be accountable for some of those choices, and that we want to put on the table some costs and some benefits, and, you know, it could be a whole other repertoire of how we want to understand the distributive effects of the law, but to be accountable for some of these choices that we made, rather than distance ourselves from saying, we lost out, we are in this marginal position that the state appropriated feministly. So I think I'll stop it, and I look forward to your questions.
Thanks, Prabha. Very interesting and very provocative talk in many ways, and I open it up to the audience. We'll take a couple of questions and then one more, and then.
So will it be okay to record the questions?
Or you're recording it?
Okay.
Any? Somebody should take the first one, and then we have another one. No? Yes.
Thank you for your talk. I just have a couple of questions, and maybe they're more like asking for clarification. One is, I mean, the term governmental feminism, it's one thing to say, it's one thing to say, to call the area, I mean, to say that, okay, you know, feminists have worked with the state in particular ways, and particularly in the area of law reform. It's another thing when a term like governmental feminism sort of assumes the idea that feminism is completely in one mode. So would you then have the same argument if you looked away from the law and law reform at other ways, other sites in which feminists work, other kinds of demands, other kinds of, you know, so that would be one thing to, you know, because otherwise the term kind of assumes that that's all feminists are doing. And actually we know in this long history that isn't, you know, that may be, and you make that case very well, that in a way, you know, there has been a focus, but I don't think still at the present moment that will tell us about the multiple directions in which, you know. The second was that if you actually looked at case law, I mean, would you get a different sense of the kind of decisions that are made, you know? Because I'm just wondering, it's one thing to do a kind of textual analysis or an analysis of the kinds of provisions, the influences and so on, except that clearly the influences, meaning feminists weren't making certain demands in a vacuum. Their understanding was also based on the case law. So I mean, if one actually, you know, in another sequel to this paper actually looked at the case law, would you then argue the way you do of this going between 2 and 3, moving towards radical feminists and not? I wonder. I mean, I would think not.
I would think yes.
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 Yeah. And the third is I didn't quite understand your this idea of looking at rape relationally. Because my understanding of the rape law is really that so many of the provisions are precisely linked to this idea of looking at rape relationally. So the idea of political power, economic power, and so on is coming very much from that idea of looking at, so, but if you could clarify that.
So, no, I think I appreciate that, and I wasn't sure if you were in the room when I started, but I think when I introduced the governance feminism project, I did say that it's, we are interested in looking at feminist influence in other zones as well. But I think being lawyers is a bit of an occupational hazard that we default to the state. And this particular introduction has to do with how feminism relates to state institutions. But I think you're absolutely right. And some of the examples I gave were of representation of women on corporate boards, or the veiling issue in France, and so there's a whole range of, or law and development, there's a whole range of areas where feminists have had influence in other arenas. And I also mentioned briefly about how, in a companion piece, I'm looking at how feminists deal with sex workers who are at the receiving end of that governmentality coming from the state through HIV, discourse, and all of that. And how their relationship to the law is somewhat different from that of feminists, and that's something that I'm comparing in a different piece. And it, luckily enough, the CLA deals both with rape and trafficking, so I think it gives us a very good opportunity to contrast how sex workers think about the criminal law vis-a-vis how feminists think about the criminal law. And it almost feels like, sex workers are where feminists were 30 years ago in relation to the criminal law, very, very deep suspicion of the criminal law. So I think but also to say that actually the relationship between feminists and the sex workers groups in this particular instance, the 2013 Act, was interesting, that they deferred, having neglected this area somewhat, they deferred to what sex workers groups were, their lead on the critique of the conflation of sex work with trafficking. Now on the second question about case law, I think you're absolutely right, and I think again Pratisha's work is testimony to the perversity of the law. But I would turn it back to say then, all the more reason why we need to have other strategies for thinking about how do we deal with sexual violence rather than a hyper-investment in criminal law. That is what is perplexing to me, where we have sophisticated ideas of power rape. We also know that the case law is perverse, but then why are we then funneling our energies towards law reform? And that's that could well be a political question, right? If the government is considering law reform, are you just going to walk away? No. But I think having a long-term view on how you might deal with this, and I think it has been long-term, and I'm not privy to what the thinking amongst feminists was, but my sense is that there has been an over-investment in the law, particularly the criminal law. So if I did the case law analysis, I'd actually argue this even more. And I think the point about rape relationally, I think is right. I think you're absolutely right. I guess I was looking more at sort of doing a distributive analysis rather than simply say. So I think what happens from a lawyer's perspective is when you see ideas such as dominance, it could actually mean a lot of things, right? When it comes time to as lawyers having to pin down where on that spectrum of coercion, non-coercion one needs to know what dominance means. So you could argue relational rape in that sense, but it doesn't translate that easily for lawyers. So I think it's just pushing down on that aspect of it somewhat.
Okay. Any other questions? Anybody else?
Let me just ask, I think we spoke about case laws.
Could you please speak into the mic?
Spoke about case laws. One is spoke about feminist governance influencing in making the laws, etc. But when we talk about the actual execution, what is the role that feminist governments will actually play? What according to you is crucial to that? Because I think that is the biggest problem that we are facing at this point in time. That's something that I'm sure you know about the Varieties judgment imposed that. As you also mentioned about feminist lawyers being what you mentioned. So that's what I was thinking that the day-to-day of it, like the execution of it, what is the most important? What's the first step? The question is where we start.
I think the first step is to take stock. I think that's the political time frame has to be quite extended. I don't think, it's always the case that, every day, if you're in a political institutional context, you confront sexual violence and you have to make certain decisions about your role there, ethically, politically. But I think as a movement, I think we need to first take stock of what has happened. I think unless we understand that, I don't think we can go forward. And there could be other concrete ways in which we assess the effects of the law. So one is case analysis, right? The other analysis would be to say, like the Hindu report on how the CLA is being used to actually criminalize consensual sex. Executing judgments.
I'm sorry, the judgments which are coming out, can that be?
Yeah, that is a starting point for discussing consent, definitely. I think the Feruki judgment is it's a very opportune moment for really thinking about consent. It's brought in lots of other issues in relation to sentencing and so on. And I think it is, once we reimagine, and I think this part of thinking about rape relation, once we think of the whole range of scenarios in which that same consent provision might be deployed by men and women in different ways, I think that would help us prepare ahead of time for these test cases rather than having a deeply contested, and it seems to me from the outside, a very painful discussion post-Feruki where people have been challenging each other's commitment to each other's friends and so on. I think there's I think anticipation, reflection and anticipation while also engaging in your own particular context would be worth pursuing.
Yes.
Governance is like what you are saying, like feminists are influencing the state and feminists are going with the state. So in this sense, the governance, like the term has been used. Like we can see vice versa, like state is also influencing the feminist work in the sense, like as you said, that feminists are excluding LGBT. On the other hand, state is also trying to exclude LGBT. So there is a kind of compromising things. Like we also won't accept them. You also don't accept them, and you do whatever we would like to do with you. So you see a kind of relationship like that.
Yeah. I don't know if it's that well articulated in the minds of the government officials, but yeah, there's no doubt that there seems to be a premium for states in supporting gender equality. Right? It's high up there on their list of priorities to be alleged in a civilized, name it, right? To appear to appropriate some kind of language of gender equality. And I think that's the challenge for the women's movement or the feminist movement, I think, because so many organizations, so many actors are able to now replay this, that I think we have to really watch quite carefully who's using it at what point, for what purpose. I think that really comes out in the trafficking context very easily, right? You can use this gender speak to push in a trafficking provision, which actually then immediately hurts another whole group of women. So I think we have to be very cautious about how all these issues also play with each other, the interrelationship between them, rather than working in silos with the state.
Yeah, I think there are two questions here. I'm not sure. One question.
I think that I had it. That's fine. So this is very, very good to think with, and I'm grateful to you for these strong points there. But I just want to ask a simple question about how do you compare what's been happening since in the last few years with what happened in the 80s in terms of what Flavia Agnes and Nita wrote about in the 90s, their criticism of the law reform phase of the 80s. There were quite a few laws, from of course the 83 late law reform to laws like the Indecent Representation of Women's Act, the Anti-Sati law, etc. All kinds of laws were passed. So in terms of what would you call that governs feminism as well? Or is there, what is the difference between what happened in the 80s? And actually, you know, it's not like, the 80s of course was the heyday itself, but there were later as well, domestic violence law was passed in the early 2002, I'm not sure. But particularly they ended up so much soul searching and criticism that was happening in the 90s. So at some level it seems like deja vu, but at a much, I mean it's just useful perhaps to revisit, you know, what was it that was going on in those critiques and those experiences. Also, I mean, since you have gone through this archive of these commissions and the representations in them, how much do these promise to marry rape cases and elopement cases figure in those debates? Because as we know now, I mean, there have been some studies post 2013 that they are actually the majority of cases, the elopement and the promise to marry cases. This is not some minuscule minority or some, you know, this is not a minor problem. This is actually perhaps, and it's probably going to be exacerbated post the reduction of, the increase of the age of consent. So was this question, this elephant in the room, really, I mean, how is it being ignored in this debate? How has it been dealt with, rather? We don't know whether it is.
Actually, I've been reading this archive over a few years, so I'm not going to immediately pinpoint to particular reports. But I have to say, and Pratisha can correct me if I'm wrong, it's come. I mean, a lot of feminists have documented the way that the criminal law has been used. Several provisions of the criminal law, not necessarily the rape law, but also the rape law, against consensual sex of this sort. How much it made it to the commissions and reports, I'm not really sure. I don't suspect that it's a major part of it. And that could well be because the elephant in the room was a baby elephant earlier, and maybe it's it's just something that's and it could also be that it's Delhi, right? It's also too hard. It's difficult to read too much also into that analysis. I mean, clearly it's a rigorous analysis, but it's only for 1 year and it's in Delhi, and we don't know how it's being used in the rest of the country. So actually, the answer to that question is an empirical one, and I think that's another thing that feminists could do actually. And it's clear that if journalists can do it, academics should have done it by now all over the country, and that's what I think is a challenge for legal academics to really trace that. And we have very blunt tools to do that sometimes, because and this is not just with rape, but with a lot of other crimes. The NCRB data is so rough that you can't really understand which laws are generating both addressing sexual violence but also generating sexual violence. And I noticed from my work on sex work, a lot of the laws are actually being used against sex workers. So our instruments may not be so precise actually to map this, but I think it would be the thing to map quite urgently to see if that is represented around the country. And I think in terms of what's changed between the 80s and now, again, I don't feel entirely competent to, because a lot of these, I think political histories are, lived through, right? You can't just, they don't always make it to the documents. I think that's a limitation of my research, but just sensing the affect, the change in affect, and I think Deepa Menon herself has written about this, that there has been a shift through the 90s from where feminists perceive themselves as outsiders to the state, had a very strong oppositional stance. It was us versus them. That has dissolved, and that with the range of gender-related projects that are up for funding, and the number of younger feminists who can actually make it a professional choice to deploy this kind of gender speak as a vocational sort of choice, not as a political position, suggests that something has shifted. The way that we are understanding our relationship with the state has changed, and it's again very unpredictable, because even with Lily Agnes, I think she's complicated in the way it's, especially given her recent outlook interview. It's hard to really place her both as a feminist and as a lawyer. So I think there's that dimension as well.
I was just reading the 1992 position. Let's just say that this old criticism which arose from the 80s experience. I agree obviously. Yeah. So I'm just saying that revisiting that. So.
If I may come in here in relation to Anuja's question about love marriages being classified. I think Verma in his report mentions that. In fact, the only place where they refuse to engage with Prevention of Atrocity Act. This is the problem I have with this whole peak of carceral feminism. It doesn't look at other kinds of legislation where rape is defined as atrocity. You had Capital Punishment in Prevention of Atrocity Act of 1989. Right? So one needs to sort of have a consistent critique then of different legislations which intersect in a certain sense. Prevention of Atrocity Act is not something which Verma at all relooks at. And they refuse to engage with the question of compromise. Some of the actually the 80-90 groups which landed up at the hearing elbowed their way into. They had to argue to get a hearing in front of Verma because that 2013 moment actually elbowed out the feminists. This impression that the feminists framed the law reform, etc., it was a struggle. And there were many arguments within, as you know. So the historiography of this moment is a very difficult thing to do, right? And what you've done is quite remarkable in terms of trying to map from the 80s to 2013, the kind of shifts in the debates around rape law reform, but it's, some of us are still struggling to really map out, which group, which argument, whatever, it's like next to impossible. So in the 80s, for example, so does that make us carceral feminists in the 1980s, right? And it's only in the 1990s there was this, I remember there was this very intense conversation here and other groups around a particular case. And there was a right-wing government at that point, and there was a very heightened debate around death penalty to rape accused. And that is the time, if my memory serves me right, restores this memory, that's when this position against capital punishment gets sharpened. And similarly with this whole question of can women be perpetrators? Again, there has been a very intense, angry, contested debate, also from queer lesbian groups. So basically said we don't want a gender neutral law. So it's not, it's not just to clarify.
No, it was in the paper. I couldn't go through it.
It's not just straight heterosexual feminism, which is saying that we want gender neutrality. But there are a lot. In a sense, it was a very, very difficult debate even to follow. And this is why this whole sort of history of the rape law reform is very hard to write about. Having said this, I was wondering whether in your if one thinks about the legal method, right, and if one looks at the kind of trial judgments which have been pronounced, and these judgments, if anybody's interested, are online, right? So there have been, from this one particular court, some more than 20, 25 acquittals, right? Where the judge cuts and pastes her judgment and finds when she acquits rape accused, she says, what should be, post-Nirmaya moment, post-2013 moment, there was this assumption that all living survivors of rape should be called, they're not dead, they should be called survivors. Now these men who have been acquitted, should we also call them rape accused survivors? This is over 25, I don't know how many judgments, right? So there is also a way in which the institutions, the judiciary, the police, etc., there's a backlash. Right? Parallel with this critique, these two things are happening simultaneously. And this entire sort of also history of what happened to judicial discretion, sentencing, was it a feminist demand in 2013? So it was removed by the ADOA bill in 2002, But it was not a feminist demand. In fact, the feminists went to the ministry and said, please return adequate and special reasons to the bill.
I didn't say that. I didn't say that the feminists played a role.
No, I know, but the public discourse is such where there is assumption that, feminists have propagated a carceral form of feminism or form, a version of governance feminism, which has advocated higher sentencing, right? And remove judicial discretion. One needs to also then pay attention to the history of this movement, where apart from this question of marital rape, house power, they actually, and it was Burma who did away with judicial discretion despite arguments against it. Right? So what is the state responding to? It is also responding to a certain crisis of institutions. Right? It's not only feminist influence on governance, whatever it is. And how, my last sort of formal question is, how would we understand the political moment today when feminism is characterized as anti-national? So there is little, influence you have on any process of law reform today. So that shift in light of the backlash and a different kind of carceral politics around sexual violence, which you then distance from as a feminist. That doesn't belong to your politics. But these things are coming together in a particular trial or in a particular case. So how do we analytically distinguish these?
Thank you. That's a lot in there. So I guess I'll just deal with the question of how do we understand the political movement. I think it would be very, very, very hard to respond to that. But I do think that there is scope. Well, I would say just as you have a period of abeyance where you don't necessarily continue engaging with the law except on a case-by-case basis where falling down to. I think what we might do is at least not silence a critique of the law. And I think, that's what I sense. I sense that if there is a critique of the feminist position in the law, there's a very defensive reaction to that. And I think that's probably not, doesn't help in having a conversation around what we do next. And I think the political decision is a symbol of that it's just ripped apart the community in a way that, probably is not so ideal. So, apart from that, I'm not really sure that I can, respond to that, but I think it's true all over the world, that there is a backlash against feminism, but particularly more so at this point in India, this movement. But I think if we could have a more nuanced discussion amongst ourselves and not, issue statements or let it out publicly, it might be one way to
Take a break from Twitter.
Deepak?
Well, there are two debates raging over across the globe about sex worker. One debate is said that sex worker should be legalized, and other is sex worker should be regularization. Simon, at present, I think we are somehow lacking the issue of sex worker in contemporary era. And what is your stand on the legalization or regularization process? I think, I personally think that the regularization is the prior condition of legalization. So, what's your stand?
I could talk for hours about sex work, and I think I shouldn't. I won't be invited back again. So I would actually don't have a clear-cut position because I've done a fair bit of empirical work around sex work, trying to understand the political economy of sex work in Sonagachi and also done a legal ethnography of what kinds of laws apply in those areas, and have then tried to see how different policy positions would play out on the ground if those laws were passed. And actually, it's very hard to tell whether women would benefit from any of those policy positions. I think right now the debate is more around whether the trend seems to be more towards criminalizing sex work. And I would just say, don't criminalize anymore, it's criminalized enough. But I think in terms of whether one prefers legalization or not, it actually depends on how the legalization is formulated. There are many different models of trying to achieve it. So there's no clear-cut answer. I don't have a clear-cut reference in the order.
Now my question is about the understanding of dominance feminism. So when you say that feminism has influenced the laws, the recent laws a lot, we have seen in the past how governments have used feminist vocabulary and taken words, taken things like empowerment and words like that, terms like that, and used it to appropriate what they are actually doing, which is very different from what a feminist result would look like, or what they are trying to achieve is actually very different from what feminists would want to see, because they've had policies which for their capitalistic benefits. I mean, in Bangladesh, in India, we have seen in different eras for forwarding different agendas, feminist vocabulary has been used. Even in 2013, we see that there is a lot of diluting in the sense of what feminism would have looked like if incorporated with law, in terms of what actually came out. So in terms of, as you mentioned, LGBT, and there's a lot of other things also. So how much of governance feminism is it really, and how much influence are we having? Is it not the government appropriating feminist tradition more than us influenced them?
But actually there isn't, but the problem, the assumption there that we are both making, I suppose, is that there are certain kinds of feminism that we think of as proper. And actually what I'm also trying to suggest is that there are different kinds of feminism, and there are different kinds of positions which present themselves as feminists, which is what I was saying in the trafficking context. And it's actually not entirely clear. So I'm not making any causal claim about how it was, us, a certain proper feminists who then became disempowered and they hijacked the law. I think it's a mix, it's a confluence of many different feminisms, and but I do think that for us, it's no longer sustainable for us to say that we are disempowered. That's what I'm trying to say. All I'm saying is that we may not have gotten what we wanted, but it's not as though we have no influence. I think there's a difference between that. And I think we have to understand that even when they hit back, that there are things that they are appropriating, and sometimes even if they don't appropriate, like the definition of consent, for example, right, was taken from what we propose. So I think at some point feminists have to, I think it's a more powerful position to be in, to say actually that we seem to have some influence. Let's see how they are misappropriating our influence and see what they're doing with it. Because I think feminists ourselves don't understand the range of situation in which that consent clause could be invoked, right? And I think sometimes we undercut our own feminist cause through the proposals we make by relying on the criminal law. So all I'm saying is, I think it doesn't help us anymore to say we are on the outside, look what they did to us. I think actually if you look at a whole range of feminist lawyers, the number of feminist laws that have been passed, that position is simply unsustainable. I think if we can have a more complicated conversation about which feminist lawyers do what and which particular provisions of which laws came from where and what is likely to happen to them, I think that's much more rewarding, and I think that will make us stronger than being in the same position of saying, poor us.
First of all, thank you for that very recent exposition on governance feminism. I was struck by the comment you made on the draft bill by feminists, in which you said some of the provisions appeared to challenge the Constitution. In our current situation, and we have to see, I think, the question of the backlash in a total context, in terms of also the now new demand for the revocation of the Prevention of SCST Atrocities Act, and in some parts of the country. And of course the more recent call to withdraw certain provisions of the Dowry Act and so on. Do you think that feminism now will be forced to go, or have to, for tactical reasons, go in the direction of invoking certain kinds of constitutional rights, as opposed to more distinctly feminist rights? Have we reached, in other words, the limits of that kind of accord? That was one question. The other is actually slightly going to repeat what people have already asked. But it seems that in the period between 1883 and 2013, we have seen a great deal of optimism related to law reform, followed by complete and utter dismay by reversals within courtrooms. So I actually agree with Janaki in the sense that the case law may tell us something slightly different, and I think Pratiksha's recent work on her reading of the Faruqi case amply demonstrates this, that we have to see read case law very, very closely, not just the emblematic one Faruqi case, but various kinds. So I'm wondering, have we now returned more recently to a position where we feel that we are actually influencing law, legislation, as opposed to just not just judicial reasoning. Judicial reasoning also perhaps partially, but more effects in terms of nuancing legislation. So where does this go? We've been through the whole. It's almost like we've come full circle.
That's very interesting. On the first question, constitutional rights. I haven't thought about this much, and it's always a promising path to take. But I think.
Sorry, if I can add just one thing.
Yeah, sure.
There's a lot of blurring these days also in the understanding of human rights, as is emerging, for instance, around this recent surgical strikes. We are constantly being watched for our response to what is being seen as a violation of human rights if you do not applaud the actions of soldiers. So this idea that human rights is something that applies not only to ordinary citizens but also to members who belong to the armed response of the state is something which is clearly blurring the idea of human rights itself. So is there something that we have to begin to retrieve in a broader sense?
Retrieve and problematize. In a way, I think that second observation answers the first, which is the fluidity of rights and how problematic rights can be. I think so. The Constitution might be an area of last resort, but I'm not particularly hopeful that you could have anything more than a liberal interpretation of rights to further those kinds of causes. So, it's if there is no option, definitely I think we should think about the Constitution and invoke it in ways that we need to. But I don't think we can expect anything radical out of interpretations of rights, because I think as lawyers we've seen how fluid rights can be and how they can be appropriated for very different interests and also different ways of thinking about the relationship between the individual and the state. So, it's tempting, but I would be careful. And the second question, I wasn't really sure. So how you were thinking? I think it is a continuous process to think about the relationship between the case law and the law reform. So maybe I'm not understanding your question right. My argument is precisely to look at the text of the law to see how they could be interpreted in different kinds of cases. So I don't see them as distinct in any way. So maybe you can clarify your question.
Well, for some time, especially for instance following Varieties, those kinds of setbacks in the courtroom, there was this feeling that we have excellent laws but we don't have justice. And that courtroom does not reflect the extremely fine, nuanced and extremely well thought out legislation. We probably have the best legislation in the world. I don't know. This is something different. So have we now come full circle in that sense? That we now feel that we are empowered enough to actually once more enter the realm of legislation and actually finessing the law in that sense. And also perhaps hoping for the best in the courtroom and the actual case.
Yeah, I think they obviously work in tandem. But of course, they're also, even under doctrine of precedent, courts don't always cite what they're supposed to. So there's all kinds of problems with the legal system and judicial reasoning. But I think that's right, and I think we have already done that, so I don't think it's something that we have to do. I think what I try to demonstrate is that, in fact, because of these perverse outcomes, I think feminists have argued for better laws, what they think are better laws, and it's not clear to me that when they come up in the context
with regards to the feminists and the state. But as far as I understand, it's quite strong between the feminists and the sex workers. And these notions of consent, rape, law, these are very crucial when we talk about women in the sex industry. In context of all of this, how do you see governance feminism having a scope for these women? And more importantly, how do they cater to them? How do they bring them within their ambit? Because
feminists bring sex
yes, because these sex workers are as apprehensive about feminists as they are about the state. So how do you see that happening?
I don't know. I think I feel very sympathetic towards the feminists actually, because I think partly maybe because some of the most influential forms of anti-sex work legal struggles have come from the US radical feminism. There's a sort of traveling package of radical feminist ideas, US radical feminist ideas that go around the world and manifest themselves in the form of radical law. But I think the Indian feminists have actually been very ambivalent about it, and I think that was okay for many decades, where they said, look, we don't think women should sell sex for a living. Okay, that's a position, but we don't want to criminalize them for their income. Right? So they did really. It was because of this deep tension that they didn't want to really, whereas the radical feminists are not necessarily like that. They want to actually criminalize the customers, which would in fact hurt the women, but they pretend that it won't hurt the women. Right? So I think Indian feminists are less disingenuous in that way, but I think it's an expensive error, because I think, and this was, the CLA process revealed that, because I think, so for example, the definition of, in section 370 of trafficking, there were crucial, the terms like, first of all, there was a conflation that the Varma Committee achieved of sex work and trafficking. And I don't think feminists intervened there until the sex workers groups read the report and said, hang on a second, go back on that. And I think they supported them. That I think is the strength of Indian feminism. I think, and in that sense, there's room for conversations between the two. But those conversations seem to are happening, but they're quite limited. And I think and I think those conversations have to happen more, because I think feminists played an important role, or were certainly there when that definition of trafficking was being drafted, and the government dropped forced labor, for instance, from there are many forms of exploitation for which you can convict someone of a trafficking offense, but they didn't include forced labor. Forced labor was omitted. And I'm very surprised that feminists had no position on this issue. And I remember this very distinctly because I presented a paper on trafficking and Indian trafficking law at CWDS. This was in August 2012. And it was a room full of feminists, and it was a very interesting response. The response was all in relation to sex work. It wasn't in relation to trafficking. And trafficking in that sense has very little resonance. It's an international construct that's just landed up at our room. But it is here, and it's here to stay. And a lot of those groups are claiming to be feminist, and they are feminists, I suppose, but they are just of a different kind of feminism. And I think, as I said, the trafficking bill is very close to being passed, and it's being drafted by the abolitionist groups. So I think I only wish there were more conversations between the feminists and the sex workers, so that we could actually have a front that pushes back on this law. And I'm so frustrated because I think there are bonded labor groups who are not talking to the sex worker groups, who are not talking to the ILO, who are not talking to the contract labor, the women who are being organized in the government sector. And it's a sticking point between sex work and the rest of the world, and that has to change.
Ma'am, during my MPhil I worked on sex work, so I had a brief field work at GB. My hunch out of it was that the state is the secondary part of it. First, there is need for creation of conversation domains between the feminists and the sex workers. And I don't know how that could happen, because that is like a big lacuna, and I don't know how that can happen. So if you could throw some light on that, how could we create those spaces of communication between the sex workers and the feminists?
I think in the context of this law it did happen, but something that's more sustainable would be, it's hard to imagine, because I think the sex workers movement itself has undergone so much change in the past decade, from the point at which they were having sex worker conferences to now literally being decimated for all kinds of reasons, and then a lot of internal politics that have not helped produce unity even amongst the sex workers. So I'm not really sure. My own experience as somebody who studies sex workers, that actually feminists couldn't care less. Not as they have a position on sex work, but politically, I think it's just not something that they want to touch. So maybe we can discuss together how we think we might be able to change this. But I think the law is forcing us to do it now. The reform that they're suggesting, the anti-trafficking law, means that we have, and feminists have to take stock, because a lot of these abolitionist groups are being funded by philanthropic contractors, as we call them now, really, really huge NGOs that are anti-migration and that have mobilized, interestingly, they've mobilized the abolitionist groups in India to feed into the law reform process, but even feminists haven't. So I think that's problematic.
Any other questions? Great. Okay, thanks Prabha. It was a really interesting session and a range of questions I hope you can also feed in to your own research. Thanks a lot for being here.